Well, good afternoon. It's a great pleasure to be here at UBC, where I once taught from 1975 to 1981. It was somewhat of a shock to go by the old building and see a big hole in the wall of my office. There were times when I was teaching there when I was tempted to put that hole in myself. So my sorrow is not unmitigated. I'm very, very pleased about the new law school that some of you in first year may get to enjoy. I'm indebted to the UBC Faculty of Law, not only for the fact that I had a chance to spend 5 great years there, but for a number of other reasons. First of all, I've had a number of excellent law clerks who were educated at the faculty, and I have benefited from their learning and grown very fond of them over the course of the year we worked together. The second subject of indebtedness is the fact that UBC has produced a great number of good advocates, many of whom appear before us regularly in the Supreme Court of Canada. And the third reason I'm indebted to the UBC Law School, and perhaps the province more broadly, is that you seem to produce more interesting, unique legal questions than any other part of Canada. In fact, my colleagues are always saying to me, what is it about BC? I think we grant a lot of leave applications from here. And I think it has to do with an innovative spirit. That's the only thing I can answer. An approach to the law that sees it in a creative way, that sees problems and looks for solutions, and is not hidebound by what's been done before. So I think you're doing a great job in this province of keeping a very lively legal culture going, and I'm grateful for that. Today I'm going to talk a little bit about Supreme Court of Canada. And I'll talk first about its history briefly, and then I'll talk a little about the composition of the court and the people that make it work. And then I'll describe how the court decides cases, how a typical case might go through the court. And then after that, as Dean Babinski has stated, I hope that you will have questions and comments and that we can enter into an interactive session. Well, briefly a little bit about the history and evolution of the court. Some people, when you say Supreme Court of Canada, if they have any vision at all, think of a big gray building sitting on Parliament Hill with a high Norman-style roof that looks like a dunce cap. It's said that Mackenzie King used to walk his dog by there, and the architect originally wanted was an Art Deco building, a flat roof, but King insisted that they put this tall roof on. Whatever the case, the roof has become a signal part of the building. Some people, when they think about Supreme Court of Canada, well, they think of an organization that for some not fully understood reason gives on occasion Delphic pronouncements which everybody has to pay attention to. And of course the Supreme Court of Canada is both those things. But it is much more. It is a living institution. It is a fundamental part of the Canadian constitutional setup, and it is an institution that has grown and evolved over the years since it was first established. Now, most democratic constitutions start off establishing a court right off the bat because, you know, you have your branches of government, executive, legislative, and judiciary. And so they put it right in their constitution. Well, we do have provision for superior courts in the BNA Act of 1867, but the Supreme Court of Canada wasn't established by the BNA Act. There was provision made ultimately for a Supreme Court. In 1875, the Supreme Court Act was passed and the court was set up. 5 judges were appointed. They went to work in the basement of one of the buildings on Parliament Hill. They sat there for a term, and the record discloses that at the end of the first term, and I quote, "The court rose, there being no business to conduct." Well, that was then. We now have, as I'll be telling you presently, a lot more cases and a lot of business. In fact, things were so slow that a couple of years later, an MP brought a bill to abolish the Supreme Court. I don't talk about that much because it's a bad idea, and I don't want anybody to do it. But it was seriously debated. The Prime Minister of the day, John A. Macdonald, gave a brilliant speech explaining, I think it's brilliant anyway, why we had to have a Supreme Court of Canada for this emerging chrysalis of a country. And the bill was to abolish the court was defeated. But we have to say that until 1949, it really wasn't the Supreme Court. It was an oxymoron, because the Supreme Court was, of course, the Judicial Committee of the Privy Council in London. Now, sometimes people would go to the Supreme Court and then go on to the Judicial Committee, but sometimes they just went straight to the Judicial Committee and bypassed it altogether. So it functioned in those years often as a sort of second court of appeal, which wasn't totally satisfactory. Just to give you an example of how it worked, you're all familiar probably with the famous persons case where the Judicial Committee of the Privy Council said that women were persons for purposes of holding public office. Well, that case went through the Alberta Supreme Court, the Alberta Court of Appeal, the Supreme Court of Canada, and then to the Judicial Committee of the Privy Council. Now, people often say, well, the Supreme Court of Canada made a terrible mistake in holding, as it did, that women were not persons. But what you have to understand is that the law of the Commonwealth at that time was clear that women were not persons for purposes of holding public office, and the Supreme Court of Canada had to follow precedent, the precedent that had been previously set down by the House of Lords and the Judicial Committee of the Privy Council. So the Supreme Court of Canada, I say in its defense, really didn't have that much choice. Then it went to the Judicial Committee, and the Judicial Committee had a change of heart and said the time had come to recognize the place of women. But that was very typical of how the Supreme Court of Canada might function, but merely as a stop along the way. And then in 1949, as we all know, appeals to the Judicial Committee of the Privy Council were ended, and the Supreme Court became, in truth, the final court. And even then, though, there was a gradual transition to it becoming a truly national court. In the 50s and 60s, Professor McCormick from the University of Lethbridge has done work on this. In the 50s and 60s, almost all the cases cited by the judges in the court were British precedents. We were still rather slavishly following the precedent in the House of Lords. In the 70s, we saw a new spirit coming in with Justice Laskin, who became Chief Justice, and after that, Justice Dixon, and certain other people who had a vision of a distinctive Canadian legal culture. Not a vision that required everything to be changed, but at least the idea that because we were a distinct country, under a distinct constitution, it was not impossible that we would find distinct, unique Canadian solutions to legal issues.